Okay, welcome. Thanks for joining us to that law enforcement panel. My name is Franziska Böhm, and we together, so with Eleni, here's the slide, we published a commentary on the Law Enforcement Directive 2 years ago, and since then we organized panels on the Law Enforcement Directive, on the recent updates, and on the case law and on reports which are published regarding to the Law Enforcement Directive. We have very distinguished experts today to talk about the newest developments in the Law Enforcement Directive and the sector around law enforcement. Yeah. So we have first Eleni, of course, Costa, who is the co-editor of the commentary, and she's, of course, a full professor of technology, law, and human rights in Tilburg at the university, and very known in law enforcement contexts, of course. She will talk about the recent case law, and afterwards we also have, not afterwards, but we also have Efi from the EDPS. She's the head of sector supervising EU agencies in the area of freedom, security, and justice at the EDPS, and she will join us with a talk about AI in light of Chapter 9 and the application to Europol. So a very specific topic, but of interest to all people involved in law enforcement. And of course, we have Juraj Seifert here from the Commission, but also from the academic perspective a bit. He's also a postdoc at VUB and can cover both aspects, with the practical and also the academic side. And he will talk about the second LED application report, explain a bit what the Commission is intending to do and what the Commission already did in that regard. And we also have a practitioner, but also someone who's writing a PhD, which is good. So both sides, a police officer, Evangelos Tsakadoulas. He will also talk about the interaction of the LED with the AI Act and the Digital Omnibus, so a very hot topic as well. And since people are joining, so maybe we can leave the door just open. So we will start with Eleni, and we have time for questions in the end. Okay, if you have a burning question, raise your hand. But if not, we will of course have time for questions in the end. So thank you for that.
Thank you, Franziska. For the ones that have the commentary, you will see that there are only very few references to the case law there. And that is what was available at that time. Because, of course, member states needed time to transpose, so then you needed quite a bit of time in order for case law to develop. So one joyful task that I am assigned every year is to present the developments on the case law. So the ones that followed the panel last year, you have probably seen the cases that were out or some that were pending, and now we are going to look at the cases that have been decided or submitted at the court in the last year. Just explaining the context of which cases I'm going to talk about. We see that several cases deal with the processing of sensitive data under the Law Enforcement Directive, and I know that several people in the room like to take notes on which one it is, so I'm going to be mentioning the numbers. First, I'm going to talk about a recent case. The number is 57 of 2023. Can you pronounce it for me?
I'm not Czech, and
I know,
I'm not Slovak either. Even though people think, seeing my name, that I'm Slovak, I'm not either Czech or Slovak. And so the case is called Policejní prezidium.
You see, you can still pronounce it.
I am Central Eastern European.
So that's why we collaborate for many years. The case was delivered in November last year and related to the storage of biometric and genetic data. In that case, the courts dealt with 3 different questions. So the Czech legislation allows police to collect biometric and genetic data of any person that is accused or suspected of any intentional criminal offense without a maximum storage period. And it also permits assessment of continued storage necessity based on internal published police rules. Case law, that is interesting for the specific case of administrative courts, supplement the law So we have the law that doesn't give all the details, and then there is case law of administrative courts supplementing the law by providing elements the police must take into account, like the type of the criminal offense, the personality of the perpetrator, etc. The Court of Justice, the referring court questioned whether this regime was compatible with the law enforcement directive requirements and whether the national case law can qualify as member state law within the meaning of Article 8.2 of the Law Enforcement Directive. That was an interesting question. The court, first of all, found that member state law regulating must lay down, where am I? I have handwritten notes on top. So the court found, first of all, that the concept of member state law refers to the provision of general application laying down minimum conditions for collection, storage, and erasure of biometric data and genetic data, as interpreted by accessible and sufficiently foreseeable national case law. So it said, yes, the way how this is working, it can qualify as member state law. The second question was referred to Article 6 and Article 4, Paragraph 1, asking whether the indiscriminate but systematic collection of biometric and genetic data is compatible with EU law. The court found on this question that the European legislation does not preclude indiscriminate collection of biometric and genetic data of suspected and accused persons, provided, so there are some conditions there, that the purposes of collection do not require a distinction between the categories and controllers comply with all requirements under Article 4 and Article 10 of the Law Enforcement Directive. The third question referred to the continuous storage of biometric and genetic data. And the court found, and I'm making summaries as you can understand, that Article 4 of the Law Enforcement Directive does not preclude legislation without a maximum storage period, provided that appropriate periodic review, and the national law was foreseeing was such every 3 years, and strict necessity is assessed in each review. So the court said this can happen exactly because the notion, the nature of the let is different in this context. An interesting point, and that was highlighted by my colleague here in the reading of the case, was that the court analyzed Article 8.2 of the Law Enforcement Directive, and for the first time said, approached the provisions talking about the objectives of the processing and also the purposes of the processing. So it was the first time when we see the court taking a broader approach on how we should interpret Article 8.2. Another interesting case, the number is 371 of 24, Omnibus. It was delivered in March this year. This was an interesting case where a climate activist was detained during a protest in Paris. He refused to consent to fingerprinting and photographing that was mandatory under the French Code of Criminal Procedure. And although that person was acquitted of the underlying offense that formed the basis of the envisaged collection, he was still convicted of the standalone refusal offense for not agreeing to the fingerprinting. So that was interesting whether this could be the case. So first, the National French Court asked the Court of Justice whether systematic collection of biometric data from any person reasonably suspected of a criminal offense is compatible with Article 10 of the LED. The second question related to the question whether national legislation must impose an obligation on the competent authority to provide a sufficient statement of reasons as to why collection is strictly necessary in each individual case. And the third referred to whether a person may be prosecuted and convicted for refusing to allow biometric data collection, even when they are not prosecuted or convicted of the underlying offense. With regard to the first question, the Court of Justice found that Article 10 of the LED precludes, so it's not allowed, national legislation providing for systematic collection of biometric data from any person that is reasonably suspected of a criminal offense, unless, So again, we have this approach where there are always some conditions that could facilitate this exception, unless national law defines the specific and concrete purposes of that collection in an appropriately precise manner, and the competent authority is required in each individual case. On the second question, the court found that, again, Article 10 of the LED precludes national legislation that does not impose on the competent authority an obligation to provide a sufficient statement of reasons in each individual case as to why collection is strictly necessary. So again, reinforcing the notion of strict necessity in this case. Finally, the court found that Article 10 of the LED, read together with Article 4 and 8, does not preclude a standalone criminal offense penalizing refusal to allow biometric data collection, even if the person is not prosecuted or convicted for the underlying offense. Again, provided that the collection satisfies the strict necessity rules and the penalty observes the principle of proportionality. So again, we see in this case necessity, strict necessity and proportionality being in the core of the findings of the Court of Justice. Next to these two cases, there are a few pending ones, and some of which we have already seen opinions of the Advocate General. A case that was lodged in January 2025, it is still pending. The number is 5 of 2025, Pilev. This is again a Bulgarian case. So we had a lot of Bulgarian cases, a small pause, and then more Bulgarian cases. So it's relevant in this case. The Bulgarian criminal procedure requires a presiding judge to verify the identity of a defendant at the outset of a criminal proceeding, collecting a lot of information. I'm not going to outline everything, but for example, full name, date, place of birth, ethnicity, nationality, place of residence, educational attainment level, marital status, so more and more and more than this. This information is then recorded in the court record and it is stored in the case file. The referring Bulgarian court considers that the defendant's identity can be verified with sufficient certainty from an identity document alone, and asked the question on the compatibility of the national provisions with EU law. For this, as I said, we don't have a decision from the court, the judgment from the court, but we have the opinion of Advocate General Spielmann, who delivered his opinion in March this year. So he first addressed the applicability of the LED to criminal courts, which is a very interesting point, because he concluded that national criminal courts qualify as competent authorities under Article 3.7 of the LED. And this is interesting because we know that there are a lot of debates where the boundaries the law enforcement directive are. So if indeed the court follows the opinion of the Advocate General and criminal courts are considered competent authorities, then we understand that public prosecutors, police authorities will also qualify as police are there already, but we have the public prosecutors and a few vague cases depending on the national situation. So it opens the doors to broadening the notion of competent authority to all stages of criminal proceedings. The second question that reached the court in this case, the Advocate General in this case was was whether the processing carried out in the context of criminal court proceedings falls within the scope of the LED as processing for the purposes of prosecution of criminal offenses. And there, the Advocate General applies a proportionality analysis. And what the Advocate General did, they went through every piece of information, like they examined the name, the date of birth, personal identification number as being necessary for identification, but he came to the conclusion that systematic collection of the place of residence, educational attainment level, etc., exceeds what's necessary for identification. So coming to the suggestion that the European legislation and the Article 7, 8, and 10 of the Law Enforcement Directive actually preclude national legislation requiring systematic processing of a very long list of data that are not necessary for that purpose. But we need to see what the court will say in the end. In September 2025, Advocate General Spooner issued his opinion on case number 312 of 2024, Directive, again, a case from Bulgaria. According to the facts of the case, a Bulgarian police officer was detained and was subjected to investigative measures as a suspect in a theft investigation that was conducted by an internal security unit in the Ministry of the Interior. In this case, the proceedings were discontinued without formal charges, but the information remained on file. So the police officer sought compensation and erasure of the data, and the central issue in this case, whether in this case the GDPR or the LED applies. And the second question, whether the storage was lawful. Again, we don't have a judgment from the court. The Advocate General interpreted Article 2, so the scope of application of the GDPR, combined with Article 9 of the LED, and came to the conclusion that the GDPR applies to the storage of data in a personnel file, where the storage pursues purposes other than the ones specified in the first article of the LED, and didn't move on to answering the second question. Now I move to pending cases that don't have an opinion yet. An interesting one, I think we are all looking forward to this, and the ones that have seen Juraj and me talk on panels, you know that this is a topic that we disagree, so we have agreed that we will buy drinks to the one who loses. So we have case number 222 of 2025. It's an Estonian case, Estonian FIU. That was lodged in March 2025, and it's a very interesting case that brings together FIUs, financial intelligence units, so from the anti-money laundering framework and the applicability of the Law Enforcement Directive. So in this case, the big question is whether data processing activities of Estonia's financial intelligence unit fall within the scope of the LED and not the scope of the GDPR. So this is a huge issue. There are 4 questions: whether an FIU qualifies as competent authority under the LED, whether the legal basis for data access refusal may be withheld in proceedings or to neither confirm or deny processing, whether delegating the power to restrict data subject to the head of financial intelligence unit is compatible with Article 15 of the LED and 23 of the GDPR with the exceptions, and whether a complete suspension of the LED, Article 14 and Article 15 GDPR rights under data destruction, potentially leaving the data subject permanently uninformed, is compatible with those articles. But I think the main burning question is, can FIUs fall under the LED? Finally, a request for a preliminary ruling was submitted by the German Bundesgerichtshof in June 2025 in pending case 416 of 2025. The case concerns a claim for compensation for non-material damage that arises from an alleged breach of the right of access to information regarding personal data processed by a court in administrative fine proceedings. And again, it is a question. The central question is, which instrument governs this processing? Is it the LED, transposed by national legislation, obviously, or the GDPR? So in sum, we have seen several questions reaching the Court of Justice. We see the questions remaining. I think a lot of them are about the scope of application, whether we have whether we apply the LED and the GDPR. We have a lot of questions about sensitive data, but I think we get more and more insights on how we should be applying the LED. So that gives us quite some room for future editions of the commentary, which I'm not agreeing to, and Francisca really wants us to do. So we will see how that goes. Yeah, so we see more and more Bulgarian cases.
Yeah.
So thank you.
Thank you, Eleni, for all these updates. I think they are also representative of FIUs here, so maybe a question afterwards and when we finish. So I would hand over to you, Ryan. Thank you, Eleni.
Well, thank you. First of all, thank you for the opportunity to come and speak at this panel again. It became a tradition, and it's sort of one of my highlights of the whole year. So I hope that this tradition will has a long life ahead of it. As Franziska introduced me already, I work for the European Commission. I work for the Data Protection Unit in DG Justice. I also am a postdoc at VUB, but obviously here I don't represent any of those, neither the VUB and in particular not the European Commission. I only express my personal views that cannot be attributed to the institutions that I'm working for. So I think it's interesting that this FIU thing is now finally before the court. It's a decade-long discussion. It's literally a decade-long discussion, because I remember in 2016 I entered a room full of FIUs, so 10 years ago, and I told them, you are not competent authorities under the LED. The LED was just adopted. Like you cannot apply the LED. You're not. And it was, wow, what is this guy from the commission saying? Like everyone was super angry at me, like I'm saying some rubbish, insane things, and finally this thing will be now hopefully resolved in the court.
We had a panel at CPD before 5 years ago when we had an FIU saying we applied the LED and the Court of Justice will be the only one tell us not to.
Like, yeah, exactly. Yeah. So now it's that time. Also, I think all these discussions or the case law, which I find very, I am very happy that the LED case law is developing, and all the discussions are very helpful that the court develops in order for us to interpret the LED better. But there are other things that are decade-long discussions like this on the delineation between the GDPR and the LED. I remember that you wrote probably a visionary article back in the day where you were critical towards the creation of this dual regime, and it was, maybe you wrote it in 2014, I don't know, but it's still a topic, right? So it doesn't go away. And then it's interesting how you managed to escape, because you spoke about genetic and biometric data case law, which is a development of a previous Bulgarian case law. But
we talked about it last year.
But yeah, but you didn't mention the name of the ministerstvo za vatrešните работи.
Why do you do this to me? No, I will refuse to do that.
Probably you didn't want to pronounce that.
No, I didn't.
Okay, so I'm gonna talk a bit about what the Commission is doing right now on the LED front. I think we are doing a lot of work, so people should know about this. This is also the year where the Commission has to adopt the second application report on the Law Enforcement Directive. And I remember when the first application report came out in 2022 that people were kind of disappointed with the lack of content in that report. But at the time, to be fair to the Commission who made that report, the experience with the LED was very limited, right? So it was a big change compared to the predecessor. The transposition was late in member states, and there was not much meat on the bones to put. And we are hoping that for the second report, this will be a much more interesting report, and that there will be much more meat on the bones. So unfortunately, all this is getting a bit late, sort of. It should have been out already. It's not out. It's going to be out probably in September or October. So there are a lot of things that are results of our work that will be visible in June, July, September, and October. So the timing is a bit difficult this year. That it's only about I can only give teasers and spoilers, and it would have been much better if the CPDP would be in January like it used to be, because then I could come with a much more interesting information, I think. But anyway, so the report that is in construction right now, the LED report, is based on 4 building blocks. The first building block is our own in-house conformity assessment work. So we have spent a lot of time in the Commission. It's a very long, tedious exercise, trying to analyze article by article transposition of the LED in every member state. This is You have seen that we had a external contractor back in the day who did some article by article analysis for us, because that it was called TPIC, that report was published many years ago. But then we could not rely only on the work of the external contractor. We had to basically check ourselves, discuss with member states, figure out whether, how the lead is transposed. Is it in one law that is specific for transposition of the lead? Is it in the law that also implements the GDPR? What is in the sectoral laws? What is in police powers acts, in criminal procedural laws? Is the lead embedded or not? So we had to understand different criminal justice systems, how they work. We have to speak with all the member states. We had a lot of informal contacts with them. And finally, we completed the entire picture. So we have the entire metrics after this round of informal exchanges with member states that we finalized in the end of 2025, beginning of this year. And we are now perfectly aware of what are the concerns that the Commission has when it comes to transposition of the lead in each member state. So on that front, I would ask you for just a tiny little bit more patience. Right? Then the second building block that is a foundation of the upcoming report is the Fundamental Rights Agency study. They organized a panel on their own panel on the lead yesterday, so maybe you already heard something about this, but anyway, that study is also not published yet, so I cannot speak what is in there, but I can say that it is an empirical study on the functioning of the lead on the ground. And I think that's the whole point of our upcoming report. It's about application and functioning of the lead on the ground, and not just what is in legislation. Is it in conformity, not in conformity? That's, as I said, only one building block, but the emphasis is on, and so I thank FRA for this work, because this was a huge amount of work. I think more than 100 interviews with law enforcement practitioners, policemen, prosecutors, investigative judges, but then also the DPOs of those authorities, the representatives of data protection authorities. So this will be, I think, very, very informative to everyone who is interested in how the lead works, but also to us for our report. And the third building block then that is very important for us is the information we got from the European Data Protection Board, because they have actually replied to our questionnaire, and that reply was made available in the form of an aggregate report in January 2026. I also, if you're interested, also invite you to visit the website of the EDPB, because there you also have the individual replies published. So you have all data protection authorities' individual replies to the Commission questionnaire published, not only the aggregate report. So you could see member state by member state what they say. And I find that quite an interesting read. And when you read the aggregate report, I think my impression at least was that there should be more alarm bells ringing than there are, And what I mean by that, I'll try to illustrate it by some concrete examples. So one of the questions in the questionnaire was about transfers by way of appropriate safeguards. And there you have, if you know the lead, you know that there is, that's Article 37, paragraph 1. You can transfer by way of appropriate safeguards if you have a binding international agreement, including enforceable data subject rights. But you also have a option which is quite giving a lot of flexibility to the data controllers, which is transfers by self-assessment. So you can come to your own conclusion that there are appropriate safeguards in a particular sector in a third country, and then you can do regular transfers, right? So that there is a flexibility tool that was very much requested during the legislative negotiations by member states. But then we see ever since 2018 that this tool is very much underused, right? So either the law enforcement authorities do not feel comfortable doing it, or they don't know actually how to do that. But in any case, the the use of that tool has to be reported to the DPAs. They need to be informed about it. And from the replies, you see that 22 out of 27 DPAs never encountered this use of this tool. So what does that mean? It means that since we only have one adequacy decision and we don't have many international agreements under 37(1)(a), it must mean that it's either over-reliance on derogations or something like that, probably. But then you see that the question about have you inspected transfers by way of derogations, 26 out of 27 say no. We never carried out any investigations in transfers by way of derogations, right? So I feel that something doesn't match here, right? Another example is prior consultation, Article 28. That obligation in LED is broader than the one in the GDPR because it's not only about residual risk. And then you look at the replies of who actually does prior consultations. And you see that only in Germany and Belgium, they are to some extent regular. Prior consultations in other member states, either never or almost never. And that is also a bit weird. It should trigger some alarms. So how come there's no need to actually, I don't know, have new situations of when you use new technologies, high risk, and then no prior consultations, right? So I think that my conclusion, personal conclusion, again, I say these are my personal views, is that it means that when it comes to the supervision and enforcement of the LED, there is still, something left to be desired. And then the fourth building block of the report is the feedback we got from the member states. So you have council position and findings on the evaluation and review of the LED. That's the document from December 2025. Another interesting read where you see that the council is very positive about the LED. Interestingly enough, the member states don't make any requests for any amendments of the LED, nothing.
Fantastic.
Everything is fine. And then there are certain concerns that are expressed by the member states, right? So international transfers, we mentioned already. Delineation, GDPR LED, we mentioned. Interaction with AI Act, also, we mentioned. But the council, and that is very reassuring for me, does not ask for change something in the LED. They say we want exchanges of best practices. We want to that competent authorities understand better how to actually comply with the LED. For example, how to better use these transfers by way of self-assessment that I mentioned, they also want, the council obviously wants more from the commission because we only adopted one adequacy decision, right? So that's on that front. Then there are some things that are interesting if you compare them to what I said before, because the council does raise some aspects as a little bit too heavy administrative burden. So they mentioned the data protection impact assessment and prior consultations, but then we see that prior consultations, they don't actually happen. So then it's difficult to square the circle. How is that then an administrative burden, right? In any event, as I said, what is important is that there are no requests for reassuring for me that there are no requests for reopening of the LED. The only thing in that sense when it comes to reopening of the LED is Article 43 of Recital 43 of the Digital Omnibus proposal, which says once the Digital Omnibus proposal is adopted, then you should see what out of this is applicable to the law enforcement sector, and you should align the LED accordingly. Another important strand of our work is where we get a lot of information is the network of LED data protection officers. So that's the council wanted exchanges of best practices. That's what we have developed this network over the years into something that is quite intensive. The commission is only hosting that network, but they actually have a lot of discussions on their own without the commission, and the DPOs there, they really reflect on how to make their voices heard within the organization, how to implement purpose limitation, how to do change of purpose according to Article 4, Paragraph 2 of the LED. What is data minimization on the ground? How do we create a meaningful system for exercising data subject rights, but without jeopardizing the investigation? So they really are invested into this. And the last point I want to make is an announcement. In about a month, there will be a legislative package proposed by the Commission, which includes the revision of Europol and Eurojust founding acts, the regulations, but also then a sort of finalization of Chapter 9 of the EU DPR, so Regulation 2018/1725 for Union institutions, bodies, offices, and agencies. Chapter 9 is so-called law enforcement chapter of the EU DPR. It has rules that are aligned with the LED, not with the GDPR. And in the context of the reform of founding acts of some or all of those agencies that apply that chapter. Now it's Europol and Eurojust, but others will follow shortly. We wanted to basically finalize this project of reducing fragmentation and harmonizing rules more and ensuring that they are, to the extent that is possible, in Chapter 9 and not elsewhere, that then creates either legislative gaps or fragmentation that is, from our standpoint, not desirable. So I'll stop there and looking forward to the discussion.
Thank you, Juraj, for these insights. Very valuable. And I think on the next point, Efi will have to say something on Chapter 9, also EU DPR. Thank you, Efi. It's your turn.
Good morning all, and thank you, Franziska, for the kind invitation to participate in this panel. I'm happy to be here with you to share the experience of our supervision of agencies operating in the area of freedom, security, and justice, and most notably from our supervision of Europol. My intervention has two parts. First, I will look at the legal framework governing AI-enabled analysis by Europol, how it has developed, and what our supervisory practice has established along the way. And this is what the EDPS has already adopted. And then I will turn to the forthcoming review of Chapter 9 and of Europol regulation and what would that mean in the current policy environment. Two framing points. The data protection framework governing Europol is set out primarily in the founding regulation, and since 2022 also in Chapter 9 of EU DPR. These instruments largely mirror the law enforcement directive, but they also introduce specific provisions that are tailored to the agency's mandate and operational context. And second point, the EDPS has been providing advice on the development of AI models already since 2021, always from the data protection perspective. Our engagement with Europol's AI-enabled analysis began in 2020 with Operational Task Force EMA, a landmark investigation that most of you may remember, in which French and Dutch authorities intercepted millions of messages from EncroChat, one of the largest encrypted communication platforms used in principle by organized crime. The scale was unprecedented and tools were necessary in order to be able to analyze these millions of messages that were including information on violent attacks, threat to life, large-scale drug trafficking. To handle this big wave of data, Europol developed its machine learning toolbox, a suite of AI models that were going to be fine-tuned with operational data held already by Europol in order to automate named entity recognition, image classification, facial detection, and other processing operations. So that was the occasion that we issued our first opinion in 2021, and there we established some foundational, let's say, principles that remain at the core of our supervisory approach until today. I will refer to three of them. First, we always require a legal basis for the development of AI tools and systems. Back then, we took a quite broad interpretative approach, and we allowed Europol to rely on Article 18.2c, which is the article regarding Europol's ability to carry out operational analysis. Therefore, we treated the development, validation, and testing of AI models as the technical preparatory steps that are necessary for proper and meaningful operational analysis. We have also reflected upon what the fairness principle means in the context of AI analysis in the law enforcement context, and we came to the conclusion that the controller needs always to ensure two things. First, statistical accuracy. In simple words, how often the AI model correctly predicts the answer. And in order to achieve that a model has high statistical accuracy, which is something that everybody would expect in the law enforcement context, the training data must reflect the operational data that the model will actually work upon. If it does not do so, then the model suffers from sample bias and its outputs will be systematically misleading. And second, we need to ensure that there is no discriminatory bias. If training data is unbalanced or reflect existing discrimination, then the outputs would reflect the same discrimination as well. In this case, we always require active bias auditing, representative data sets for the development, a regular monitoring and retraining of the models. And the third one that I would like to mention is the human oversight and the governance of human oversight. Human review appeared in all the DPAs we have received so far, submitted by Europol and other EU agencies as the primary mitigation measure for every risk. Yet the documentation that we received in many cases did not provide specific information as to who performs the review, when the review occurs, what it covers, what error categories are being assessed, and most importantly, how the findings feed back into model improvement. Therefore, always we require and we stress that human oversight needs a governance architecture in order to serve as an actual safeguard. Moving now, this was before the 2022 Europol reform. Moving to the 2022 Europol reform, something quite unique happened, and the legislator provided Europol with a very concrete and dedicated legal basis for the development of AI models and systems with operational data, Article 33A. This is a very specific article for research and innovation in Europol. Therefore, since then, for the development and fine-tuning of models, Europol can no longer rely on the general operational analysis provision that I mentioned before. Now they have to use and they have to stick to the strict safeguards that are provided in Article 33A. Under this provision, the processing must be strictly required and duly justified. Special categories of data, again, should be processed only if they are strictly necessary, and all data must be held, and this is quite important, in a separate, isolated, and protected environment, processed only for the purpose of developing the model, and then erased once the project is concluded. And this reading of the new regulation was reaffirmed in a more recent opinion that we issued in 2025. In this opinion, we also took a stance on what would be the legal regime that governs the processing of open source data for fine-tuning AI models, and we concluded that even open source data, when processed for developing a model that is going to be used in an operational context, qualify again as operational personal data and should apply the regime of Article 33A. Another major issue that we had to address and the legislator had to address was the processing of large and complex data sets that include data that have not been categorized, what we call non-DSC data. And I explain, under the Europol regulation, the agency may only process data relating to specific categories of data subject, suspect, future potential criminals, witnesses, victims, and so on. But it's not allowed to process data on individuals that have no link to a criminal activity. And the structural problem is real because you cannot categorize data subject without first processing their personal data that have not yet been categorized. And to address this issue, the 2022 reform gave Europol two legal bases, Article 18.6a and Article 18a, and in our view, both allow pre-analysis or analysis of operational data, also when it is AI-assisted. And now I come to the review of Chapter 9 and the Europol regulation as shortly as I can. We support what it seems to be the intent of the Commission to harmonize, of course, the applicable legal framework in the JHA area as long as we follow the lex specialis approach, meaning we can harmonize what can be harmonized and we leave to the founding acts of each and every agency what is really specific to their legal mandate. And with an example, transfer regime, data subject rights, the powers of the EDPS can and should be harmonized, but purposes of processing or categories of data to be processed or categories of data subject, in my view, and now I speak with my personal view, should remain in the founding acts. And we always have to keep in mind that it will not be only the review of Chapter 9, but also the review of the Europol regulation that are coming together. And they are the two sides of the same coin. And this is as well framed in the current political environment, and we would expect that this would reflect the strong narrative already found in the internal security strategy, the objective of the Commission to turn Europol into a truly operational police agency by making changes to the Europol regulation, considering that the reform in 2022 was not successful enough and did not solve the issue of big and large data sets. We consider that this is not the way it should be framed. Our audits have shown that these two provisions have not been used enough by Europol, so there is no genuine way to say if they fall short or not. And if I focus, and I will conclude in 2 minutes, on the AI, on the development of AI tools, the reform of the Europol regulation and Chapter 9 would have the opportunity to answer the question of whether the dedicated AI regime that currently exists for Europol on 33A will survive, whether we would have a general regime for AI development in Chapter 9, maybe having inspiration from 33A or even from 88C of the digital Omnibus proposal, which both provide certain requirements and safeguards for AI development, or whether a third pathway, whether we consider that the tasks and the purpose of processing for the agencies operating in JHA area is enough by themselves from the development and use of AI models. And I would just close saying that AI in law enforcement is no longer experimental, it's reality. We need to see how we govern it in a way that preserves lawfulness, necessity, and trust. And I will stop here. Thank you.
Thank you, Efi. Maybe one very final question. What is your opinion? What would you prefer, actually, from all of these 3 options you mentioned in the end?
I would prefer that we have a provision, I don't know, maybe 33A is too strict, but something at least like 88C that sets the safeguards in order to develop AI models and operate them, and not leave it in the general tasks that EUIs have to perform.
Okay, thank you. Thanks a lot. I'm not our final speaker, but not the last one. Thank you. Evangelos. And now we need the slides for the technical.
Please,
not the slide.
Please the button device.
Yeah.
A police says
Is it
it's
this
underway.
one?
Yes.
This one.
Thank you. Good morning. Thank you for the invitation. I'm happy to be here with you. I have prepared a presentation. Is on the screen to facilitate.
Be close to the mic, otherwise no one is following.
Oh, no. To facilitate the monitoring of my intervention today. Its title is the Law Enforcement Directive and the AI Act, Navigating the Composite Compliance in AI-driven law enforcement. The slides does not change. Okay. So the central question of my speaking points today is how can the AI systems in law enforcement be governed coherently when the regulatory framework is divided between data processing and system regulation. The Law Enforcement Directive is the core legislative framework for the governing of data processing in the real enforcement, for instance, for collection, storage, and usage. The AI Act relies on the life cycle of an AI system based on the risk classification logic and the pyramid that classifies AI systems into prohibited practices, high-risk AI systems with transparency obligations or a minimum or almost zero impact for fundamental rights. But in this landscape, the integration of AI, artificial intelligence, is not simply testing how the Law Enforcement Directive applies. It is testing the logic of the Law Enforcement Directive, and the base of this argument is that these two legislative acts based on two different logic. Law Enforcement Directive on data processing and the AI Act on AI system, so we have some technologies relies and regulated under these two different logic. So what emerges is a composite compliance architecture that is not yet fully aligned. The first, the first tension I would like to mention is the purpose limitation. As you may be aware that the Law Enforcement Directive stipulates, foresees a very clear rule that personal data are processed since a purpose has predefined ex ante. But nowadays, modern law enforcement increasingly relies on large-scale unstructured data sets where the relevance, the purpose, is not known in advance. I will refer to two practical exams from the operational policing reality. One is during digital forensic investigations when the police have seized devices, for example, mobile phones, and forensic experts extract the content and follows the processing and analysis of this data. The second example is the usage of AI-supported analytical tools across unstructured data sets. For example, I can mention telecommunications data, metadata, financial transaction data that requires the use of such technology. And the aim is to identify patterns, correlations, criminal offenses, other criminal networks. So a purpose to predefine in advance ex ante is very hard. So in such environments, the processing is not purely entirely predefined ex ante, but partially emerges through the processing itself. What does that means in practice? That processing is no longer simply the consequences of the processing, but it increasingly becomes the mean that the relevance, the purpose, is emerged. So we are moving from a purpose-driven to a discovery-driven processing in the AI context. Now about the Artificial Intelligence Act, we can mention that the AI Act does not simply complement the Law Enforcement Directive, it structures the space where the law enforcement directive applies, especially in intrusive law enforcement applications such as the biometric systems or the individual risk assessments, including profiling. At this point, to highlight that both these applications are considered as high risk in accordance with Artificial Intelligence Act. So the AI Act poses constraints at the system of this technology, and not only for the data processing. So the legality does not start when the personal data processing is in place, but it regulates all the life cycle of these technologies. And this becomes more clear when we have to speak about the intersection between data protection impact assessment and fundamental rights impact assessment. Under the Law Enforcement Directive, the data protection assessment is conducted prior to the data processing. Conversely, under the AI Act, the risk is a constant iterative process monitoring the compliance of an AI system with the obligations of the AI Act, especially for high-risk use cases. And in particular, for the data protection impact assessment, I would like to address one question. For example, if a provider of an AI system performs a data protection impact assessment for the training and development of an algorithm, the deployer then of the AI system operates this technology on the ground in practice and processing different personal data in a different operational context is required to perform a new or an updated data protection assessment beyond the fundamental rights impact assessment under the Article 27 of the AI Act, which regulates the high-risk use cases when public authorities leverage them. So the AI Act follows the life cycle of the AI system, and the Law Enforcement Directive follows the life cycle of the data processing. And the question is when the intended purpose of the AI system that the provider can define for a high-risk AI system can extend across the entire life cycle of the system, or whether its new processing operation triggers a new data protection impact assessment. So, for these reasons, it's vital to ensure the complementarity between data protection assessment and the fundamental rights impact assessment. And the conclusion is that the compliance is not simplified, so it becomes layered since the AI Act is in place. A similar divergence is the distinction between human intervention, according to the Law Enforcement Directive, and the human oversight stipulated under Article 14 of the Artificial Intelligence Act. So decisions based only on automated processing are, as a rule, under the directive prohibited unless it's authorized or subject to safeguards. And those areas are very substantive. For example, we can refer to human intervention, to express a view, to challenge this decision. And the objective of this provision is not only to a human to get engaged in the automated decision making, but to preserve the agency of an individual. By contrast, the AI Act incorporates the human control by design. So it enables humans, the operators of an AI system, to monitor its behavior, to detect any anomalies, to avoid over-reliance, and intervene when it is necessary, for example, stopping the operation, the function of this algorithm. So control is not exercised after the decision. It concerns and applies for all the life cycle of the AI system. And one of the considerations emerge from this statement is that we are moving forward from human intervention to human control by design in the case of high-risk artificial intelligence systems. A controversial matter, if I may define, is the high-risk classification and the filtering mechanism of Article 6, paragraph 3. This provision is a window for the provider of high-risk AI systems to declassify a high-risk AI system based on the justification that this does not pose significant risk for fundamental rights or not materially influencing the human decision. And the provider of an AI system leverages this filter mechanism does not simply provoke a declassification of a high-risk processing of personal data under the AI Act. So declassification does not eliminate the risk, and the use of this filter mechanism does not, in principle, precludes the provider and controller of an AI system precludes to perform a data protection impact assessment when it is envisaged by the Law Enforcement Directive. A more fundamental issue, of course, is the gap for the law enforcement authorities to train and develop AI systems. There is not a clear legal base at this moment into the Law Enforcement Directive. I have here the proposal for scientific research, but considering some target amendments derived from the Digital Omnibus and the respective guidelines of the European Data Protection Board about the scientific research, I think that is not a grounded option to based on. Of course, the Digital Omnibus proposal and one of the target amendments of the GDPR is the introduction of the new article 88C, that provides the legitimate interest as a legal basis for the processing, deployment, and training of algorithms. So we need to further explore if a legal basis for the training of algorithms is any more necessary for the law enforcement authorities. And I will not stay a lot on that because Vathia next to me has elaborated a lot the basis of research and innovation for Europol to train, validate, and test algorithms. And the last point, which has a more, let's say, operational perspective, is how to distinguish profiling with operational analysis. Profiling is, of course, is defined by the Law Enforcement Directive and concerns automated evaluation or prediction of personal aspects. Operational analysis is as well a definition under the Europol regulation that contains methods that Europol use for the processing of data and evidence supporting criminal investigations. And considering that advanced AI-supported analytical tools identify patterns as behavioral indicators or generate predictive preference, so that it is met is a gray zone when an operational analysis ends and the profiling begins. To wrap up, we have two accountability logics: Law Enforcement Directive on data processing, AI Act on system governance. The challenge is not to comply separately with each of them, but how to make them work together. And then this leads to a broader question: if this is the current framework, and particularly the Law Enforcement Directive, fit for a purpose of an AI-driven policing environment, or it is more an explicit legislative response needed. One may ask if the time has come for the Commission to take a legislative initiative for targeted amendments to the Law Enforcement Directive, for instance, on AI development, data reuse, and safeguards of a system. And at the same time, of course, the Commission is expected to unveil guidelines on the interplay between the AI Act and other union legislation. I hope that a specific part of these guidelines will be dedicated to the intersection between AI Act and the Personal Data Protection Framework. But whether it's a guidance or a legislative reform, the question and the challenge is the same. It's not whether a human is involved, it's whether the human remains in control, notably in law enforcement, criminal investigations that are characterized by sensitivity and high potential impact for fundamental rights. Thank you.
Thank you, Evangelos. Thanks a lot. I think we heard a lot of new things here, and also on the compatibilities between the AI Act and the LED provisions, which is quite interesting. Now we have 10 minutes for discussion, so I will not misuse my role for questions. So we heard on the case law, on the Commission report, on the EDPS view, on Europol and AI, and on the LED and the AI Act. So please, if you have questions, raise your hands. Thanks. Perfect. The first question. I think it's not. No. Again.
Now?
Yeah.
Sorry, it's a bit loud. So to follow up on what Yura said, coming and listening to your panel is actually also one of my highlights, because it's really an exquisite panel. Maybe some questions and perspectives from the ground. You were mentioning the case, the upcoming case at the Court of Justice regarding the applicability of the LED or the GDPR to financial intelligence units. And actually the perspective from the ground is that maybe that's not that important to us, in the sense of both allow for the limitation of rights, but the most important issue at stake is to really be able to limit those rights. And although I am very, very happy that you disagree with URI, because I also disagree with URI, and because we do apply the LED, and I'm a firm believer that the LED is more suited for our operational analysis, I am wondering whether you can share your views about question as to whether you can limit this right indefinitely in light of the jurisprudence of the Court of Justice and jurisprudence of the Court of Human Rights in Article 8. Can you indefinitely limit the right of access? That's one of the main questions that was asked. And we can, whether we apply one or the other, as long as we can limit the right, that's the most important issue at stake. If you allow me, I will go through the different presentations and then give the mic back to you. As regards, I've really enjoyed your comments about AI development and about the issue of a legal basis, because we do have this question about whether we need a legal basis or not. My remark would be, like, AI doesn't come from nothing. It's not like we go from an analog world to an AI world. So there are different levels and stages of automation. And we have asked ourselves the question as well, do we need a legal basis for a specific type of operation or not? And so far, actually, we don't specifically have one and rely on operational analysis, but the law will be under review because of the whole AMLA package. So we are asking ourselves this question as well. You have the IT structure and the IT infrastructure that you continuously need to update. In that framework, you also work a little bit on the level of automation, right, on the automation. But when you discuss AI development and the use of AI systems of specific very specified high-level AI systems, then the issue becomes more sensitive. So I'm happy about the remarks about Europol. I don't know if you can make any comments whether the changes in legislation come because of the whole discussions around the pressure cooker, yes, of Europol, the shadow database they were supposed to have in place for years. I don't know if you can comment on that. And I have many more questions, but maybe I will also leave the chance for other people and maybe just sum up and to make the issue even more complicated. Under the AI Act, FIUs, it's in among the recitals, FIUs carrying out administrative tasks, this is what the Commission says, analyzing information pursuant to anti-money laundering legislation should not be classified as high-risk AI systems. But of course, you say it's administrative tasks. Now, if the Court of Justice says we're law enforcement, all this is very complicated. Thank you.
Thank you, Andra. This was a question from the ground from one person working at an FIU. Thank you, Andra. I think the first question went to Eleni.
Yeah, thank you, Andra. Actually, yesterday I was at the EDPB and we were talking about the relationship between the anti-money laundering framework and data protection. And this is one of the questions that nobody can give you a clear answer. I'm not sure if we should go very much into the details, but actually there is a big debate whether, and I was looking for the law because I haven't printed it out, whether we can apply a very specific detail in the definition of recipient. And if you allow me, I will read it out. So we know that a recipient is a natural or legal person, public authority, agency, or another body to which the personal data are disclosed, whether a third party or not. But here comes the catch. However, public authorities which may receive personal data in the framework of a particular inquiry in accordance with member state law shall not be regarded as recipients. Yeah, some people are smiling. So if we consider FIUs falling there, then they don't have the data, right? Yeah, rolling eyes. I will not say more because it's a very debated issue, but I'm just raising it as an issue of really a big problematization, especially in view of the case law of both the European Court of Human Rights and the Court of Justice regarding the right to notification as soon as the investigations are jeopardized. In completely different context, but by analogy, I think the logic would be the same. And I pass.
Would you like to continue on that or not?
No, he has another question.
There wasn't a question for me, it
No,
was
there
for
was another
Evie.
question.
Yeah, for Evie. But
Okay, for the legal basis, indeed, as you see in the beginning, we use the legal basis, the task of Europol, and we considered that this is enough, but then the legislator came and gave a specific one. And it remains to be seen. Both ways forward could be valid. And what the Commission did in the digital Omnibus proposal was not to provide a new legal basis, was to explain that when private parties use the legal interest legal basis, they need to take some safeguards. So I think that could be a valid approach, that you have the legal basis already in your tasks, and then it frames what kind of safeguards you need to take in order to develop under this legal basis. For me, that would be a valid way forward. And as to the article with regard to Europol, most of the article there referred indeed to computer forensics network, that these tools that I referred to was indeed applied there, but the pressure cooker, which we were not aware of, and I think we can say that we will further look into it to see what was there, seems to be a tool, an internet-facing tool that could be working without the whole security safeguards that should be in place. But we do not really know if it is, and we don't expect it to be as big as the CFN. But we will look further into it because this was not known to us as a tool, but this did not trigger our thinking about the legal basis of the processing.
okay, thank you. Did it answer your question, Andra? Thank you. If there is a further question, please raise your hand. If not, I think it's yes.
Thank you. John Keys from Privacy Next. Just a very quick question. Thank you, Yura, for that very useful insight into what might be coming in the lead review report. I have a particular interest, as you probably know, in the transfers issue, and certainly there seems to be now some growing evidence that there's some difficulties in relation to what transfer tools law enforcement authorities use. So it seems to me that, and it's disappointing maybe that the Article 37 guidelines haven't created more, more confidence so far. But I was just wondering, it seems to me that the missing part of the jigsaw might be now some guidance on Article 38 of the lead. And so it's a question for Evie, I suppose. Are there any plans that you're aware of to produce guidance on Article 38? And if not, maybe that would be a good next place to start. Thanks.
Well, from my side, obviously, I cannot say what the EDPB guidelines, should be made. If it was up to me, there would be many more guidelines on the lead. I must admit I'm not aware of the such plans. I know that they are working on the guidelines on the rights on the chapter 3 of the lead, so rights, data subject rights. I know they're working on those right now, but I haven't heard that they have any plans about Article 38 guidelines. So I don't know if you can also not speak for the EDPB, but maybe you know more than me.
This is my understanding as well, and maybe Plumman confirms that there are no plans for Article 38 guidelines for the time being.
Okay, thank you for your question. I'm also very interested in this topic, but it's a pity also that, of course, we don't have enough guidelines on that. Maybe there's something to come from DPAs. Okay, thank you very much. I think the time is already over, and I'm sorry for that. Thank you for listening. I hope you took some insights for your work or daily work. Thank you very much, and thanks to all of the panelists. Perfect, thank you.